As technology advances and as we change the way we live as well as work, our planet is becoming smaller. We move across countries and around the globe.
Good evening, ladies and gentlemen. Welcome aboard.
This moving and changing to different countries means our financial solutions need to be more agile, more adaptable, and more complex. As global citizens, we want to help you navigate this new world and build for a better tomorrow.
Welcome to the third installment of the Momentum Investments Global Citizen Masterclass series, which is fast becoming the most watched and anticipated online event. I'm thrilled to be here today, anticipating an enriching discussion that will provide you with deeper insights to craft effective advice strategies for your global citizen clients. Our goal is to equip you with practical strategies and insights that will elevate your ability to serve the unique needs of global citizens. Now, for a bit of housekeeping, we've gone ahead and applied for those ever-elusive CPD points. Please do us a solid and watch the full session, adding your ID number to the CPD section so we can make it official. And guess what? You've got until the end of April to catch up on all the wisdom shared here and snag those CPD points. It's like a gift that keeps giving. Look out for your CPD certificates cruising into your inbox sometime in May 2024. Please also feel free to ask questions in the Q&A section, and our speakers will either answer them live or get back to you after the event. You will also find more information about our speakers under the Speaker tab on the top menu bar, or if you scroll down, you can download the PDF presentations. Please engage with our speakers and enjoy the event. First up is Ferdy van Heerden, CEO of Momentum Investments. With over 2 decades of experience in the financial industry, Ferdy brings a wealth of knowledge and insights into the ever-evolving landscape of global citizenship and its profound implications for investment strategies worldwide. His expertise and leadership have positioned Momentum Investments as a trusted partner for individuals navigating the complexities of international finance. Without further ado, let's welcome Ferdy to shed light on the strategic approaches essential for success in today's globalized economy. Ferdy, the floor is yours.
Thank you, Francois. Good day, everyone. It's really great for me to be here with you. I hope that you enjoy the session and that you will find a few ideas that could help you in advising your clients who fall in this category of global citizen. When the Wright brothers successfully took flight in December 1903, I wonder if they really imagined how their success would contribute to creating global citizens. And then, of course, COVID and the rise of technology over the last decade or so has also contributed to multi-country living by having the opportunity to really work from wherever you are. Being a global citizen is no longer the domain of a few. It has truly become much more the norm, especially perhaps for younger professionals, but also those who chose to spend their retirement or final careers elsewhere. These are therefore remarkable times in which we live. But we often do not plan adequately for what happens when we stop living. Where do our assets and debts go? Especially if they are domiciled in very different countries, where state taxes and requirements could be very different. And then who should your dependents and beneficiaries contact for help in tough times and in very difficult emotional times? So where we go when one passes one thing, and that's not the purpose of today's conference, but where our earthly remains go is. So often we do not pause to think about and plan for this, and then we leave it too late. Anyone with a global footprint should plan adequately in advance, as it may take many, many years for tax status to become clear or for domiciliation in particular jurisdictions to settle. So there are many aspects to consider if you are a global citizen. For example, different legal systems, which include inheritance laws, tax implications and so forth, investment complexities, globally diverse portfolios, the overall process that your family and executor would need to follow. And then, of course, fairness in wealth distribution amongst beneficiaries residing in different countries is a very different aspect to consider. But mostly, having a trusted advisor that can advise and support you and your dependents on all these aspects are important. Take me, for example. I've been fortunate to have lived and worked in South Africa, in Switzerland, and now in the UK, where home is at the moment. But at the same time, when retirement happens for me, I think at this point in time, Portugal will most likely become my preferred base. So for me, it is and was very important to ensure that I carefully navigate all of these different jurisdictions and different environments, from a tax perspective, but also from a living perspective. And more important, the future of when inheritance becomes the focus. In fact, that future needs to happen today, as it often takes years, as I said, for financial affairs to settle in different jurisdictions. But for me, as an individual, it became clear many years ago that there often is not only one advisor also that can assist, given the technicalities of local tax laws and various double tax treaties. It is therefore important to ensure that affairs are structured using trusted specialists in different jurisdictions, supported by the established product providers and solutions that have stood the test of time. I've experienced the value of a trusted financial advisor myself, who has global expertise and acumen, who could help me to clarify how I need to think about global affairs. This definitely reduced my anxiety levels and guided me in my planning. So I firmly believe in today's environment, where there are many SA clients globalizing their financial world, a global-minded advisor is absolutely key. So as you can gather, I still have my SA advisor, but with his guidance, I also have relevant specialists in the UK, in Portugal, and in South Africa to support the implementation and execution of advice that he guides me on. At times, they need to engage with each other and review what the global affairs look like, and to ensure that each jurisdiction is in good order. The more they are interconnected, the better. And this is what this webinar is all about. It's to create awareness of the importance of global estate planning and to ensure that your clients who are global citizens can be advised adequately. Thank you very much.
Thank you, Ferdi. Now, let's dive into the crucial discussion on international succession laws and their impact on estate planning across borders. We'll unravel the intricate legal frameworks governing asset transfer, offering insights and strategies to navigate this complex terrain effectively. Join us as we explore how these laws shape international estate planning and discover key principles to safeguard your clients' legacies across jurisdictions. Sharon Hamann, a senior legal advisor with Momentum Distribution Services, is joined by Amanda Moelman and Emil Hofmeyer, legal advisors at Momentum Distribution Services, and Senusha Naidu, a legal advisor at Momentum Financial Planning.
Thank you, Francois, and thank you, Ferdi, for sharing your story with us. It is becoming more and more common to be faced with clients that mimic Ferdi's situation and circumstances. We often find that clients have international estates and that we have questions on uncharted territories that we are faced with. We often see clients where they are South African residents with a lot of assets abroad in different jurisdictions, and then we see a growing trend where we've got South African nationals choosing to live abroad but still retaining assets in South Africa along with the rest of the world. Both bring about potential complexities, and hence we have these global citizen sessions so that we can desensitize ourselves to act as a reminder that you are not alone when you're advising your clients. In our first two global citizen sessions, we highlighted many important considerations to consider when planning for your global citizen client. And an emphasis was on the tax residency in our last session and the impact that can have on your planning. We had a lot of questions and feedback after that session and emphasizing the relevance of this topic. And we hope that we can provide you with some food for thought in today's session as well. As you know, we will be focusing on international succession planning. Succession planning can only be done successfully if you have a thorough understanding of the succession laws that apply to each jurisdiction, where the individual is situated, but also where the assets are situated. And the real risk is that you can be faced with areas where you've got conflicting laws. But a little bit more on that later. I think the starting point would be to give us a definition on international succession planning and succession laws, and whether they are actually the same thing or whether they are two different concepts. Emil?
Well, Sharon, yes and no. The one is really dependent on the other in a wider sense of the word. Succession planning is basically the transfer of an estate upon the death of a client from the deceased estate to the beneficiary or heirs. International succession planning becomes necessary when a deceased residency and the assets they own is not in the same country. So the typical client will include those referred to earlier, the SA resident holding assets abroad or the SA national holding assets worldwide and even in South Africa. Succession laws provide for a legal landscape in which this international client's estate is administered and ultimately transferred. It is concerned with the transfer of assets upon death, recognition of trust, recognition of foreign wills, forced heirship, interstate succession laws, and inheritance tax. And there's many more which you have to look at when you do international estate planning.
Thanks, Emil. So maybe just to summarize, international succession planning will depend on the succession laws applicable within a jurisdiction. So the laws will give us the legal framework in which we have to do the planning. And I suppose the challenge comes in where you're faced with multiple jurisdictions to get a grasp on all those succession laws that you're going to be working with. So I think maybe a good place for us to start is to look at succession laws in South Africa, because not only will the client that's a resident in South Africa be faced with the succession laws in South Africa, that client living abroad with assets here will also be impacted on it. So Amanda, maybe you can take us through that.
Sharon, I think most people will be quite surprised that most of them are very familiar with our succession laws, even if they're not able to list them when asked. In South Africa, succession laws are based on the following. You have your Matrimonial Property Act, which deals with the division of assets based on your marital regime. Then you have testate succession, where a client leaves a valid will. The succession laws we will rely on is the Wills Act to determine if the will is indeed valid. And if there is no will, intestate succession will apply, in which case the Intestate Succession Act is relevant. And then on a practical note, we have the Estate Administration Act, which will prescribe the administrative process to give effect to the distribution of these assets in the estate.
Okay, so we are sort of starting to get a picture that you will have a deceased estate. You will obviously have an executor that then has to determine was there a will and whether it was a valid will. If no valid will is found, or if the will that is on record is not valid, then interstate succession will apply. Yes. And then the executor will have to follow the process in terms of legislation. That's why a lot of people complain about the duration of estates, but it's often a legislated time period that they have to deal with.
Yes.
And Sharon, that's also why it's so important to have a will to prevent the interstate succession to come into play.
Yeah, and I think maybe in a global environment, we probably will be faced with the same dilemma.
If
because,
not more.
Yes, because it's probably safe to say that if those acts that we generally see on their own makes up our succession laws, that there should be fairly similar succession laws in the rest of the world.
Yes.
And that it should be pretty generic because everybody has the same things to sort out. So Nisha, maybe you can tell us a bit more about that?
Indeed, Sharon. Most of the countries will have a similar framework, especially the common law countries like the UK, Australia, and the US, where freedom of testation applies, meaning that the client can determine and prescribe how their assets would be dealt with upon their death in terms of their last will and testament. But by dealing with civil law countries like France, Italy, and Spain, you have to contend with forced heirship. And the rules are very specific. It dictates specific laws around the division of assets between parents and their children. And each country has a very unique law in this regard. A client holding assets across multiple jurisdictions will have to face multiple administration processes in order to finalize the overall estate. And as a result, they will have to proactively plan to ensure that the heirs are not faced with the challenges that an international estate can bring about.
Yes, it can be quite challenging. And if you think about it, not just for the heirs, but for the financial advisor that has to put this plan together. And just a note on forced heirship, obviously keeping in mind that each one of those countries will have a different set of rules. So we can't just have it, there's no generic forced heirship rule that applies to say this is how it will be. And a lot of countries, and even South Africa, we do have a bit of forced heirship if you think about the Matrimonial Property Act. There's certain things that you can't change because of that. If you die without a will, interstate succession is a form of forced heirship. Once again, it's showing you why the will is so important, and then when you deal with those civil law countries, why it's so important to make sure that the will and the forced heirship rules that they have applicable in those countries can actually work together. I think maybe to explain the point a bit further, we should look at an example. And I've thought of an example of Pete. And Pete is a middle-aged person that is widowed, just because I didn't want to deal with matrimonial property in this discussion today. And he's got children, 3 children living across the world. They're majors. One is living in the US, one in Australia, and one in Mauritius, for argument's sake. And Pete is a South African national, but he's working and living in the UK. He's a tax resident in the UK. And he has assets across the world, being in South Africa. He's got some assets in the UK, in the US. He's got some investments. And then he's got fixed property in France. So he's living the dream and sounds very similar to Ferdy's story. So if we had to determine which country's succession laws will apply, and in terms of which country's laws his estate will be administered, it can become quite tricky. Because will it be based on Pete's nationality, his domicilium, the residency where he's living at the moment, or will it be where the assets are situated? Amanda?
Well, it is commonly accepted that the succession laws of the country when asset is situated should apply, which sounds simple enough. But if you think about a client like Pete, it becomes quite complex. He could perhaps still be seen as a South African due to it being his domicile of origin. He is also ordinarily resident in the UK, and we've said he is a UK tax resident, and then he has assets all over. So we literally have 4 jurisdictions associated with Pete, and let's not forget the 3 associated with his heirs, his children. So that can also play a role when considering which product solutions to use and which structures, like trusts, to put in place. So a solution for one can be a hindrance for another. So the question is then, how do you determine which jurisdiction's laws to follow, and how do you plan for it?
Well, Amanda, in Pete's scenario, we will have to consider each country's succession laws before we can make any final decision on it. We need to consider it and see how it will impact on each other. And then only after we've done that, you can make a final financial plan for that client. As South Africa, US and the UK recognize freedom of gestation. Each of those countries will need a valid will to transfer their assets. If there is no will, the interstate succession laws of those countries will kick in, and that will apply to that estate.
So it sounds fairly simple. But it doesn't sound simple if you really think about it. Because what if Pete only has one will that he drafted many years ago while he was still in South Africa, and that's the only will that he's got on record? So it might not even refer to some of the assets he's got abroad, but that's the only will we have. And does it mean that we will then have to follow that will? So how can we be sure that the will that he drafted in South Africa will be accepted as valid in the UK and in the US? Can we assume that the requirements for for a valid will in South Africa is in fact the same across the world, or should we actually be thinking a bit further?
So Sharon, as a general principle, the will is valid if it complies to the law of the country where it was drafted. But each country will have their own laws to determine the validity that they will apply if relying on a foreign will. So there are a number of international treaties that assist with the validity of cross-border wills, with the aim of limiting instances where a client's will is not accepted. You have the 1961 Hague Convention, which provides guidance when determining which country's laws will be used to determine if a will is valid.
Okay.
There is also the Washington Convention. It provides guidelines or requirements to determine whether a foreign will is valid. So, if applicable in a specific country, it can provide some peace of mind when relying on one will for his international estate. It can provide legal certainty to know that one will can indeed work effectively, or perhaps not.
But how do they, the process works if, must I have a signed will in each country?
Yeah, that's tricky because also, how does your financial advisor actually know which treaty is accepted in which country? So the question, there's actually more questions that come along rather than answers.
It's not that easy, and it's, we regularly get the question, do I need a will in every country? So basically what you say is, it's acceptable, but that will must do its rounds around the world.
Yes. So it's not necessarily foolproof. Even if you have the treaties in place, that to say that your one will be accepted everywhere. Just again emphasizing the importance of the financial planning process and trying to make sure, or be as sure as possible, that the will that you are relying on, if you do decide to only do one will be acceptable in the other countries where assets are in fact held.
Situated, yes.
Yes. I know later on in the discussion we also have Jeff and Lucy that will discuss the pros and cons of having single and multiple wills. So we are definitely going to look at that topic a bit later in the session today. So it's important to note that no matter whether you decide on having one or multiple wills, the country in question's laws will dictate whether that will or wills are valid and acceptable, and if not, you can be faced with interstate succession, which can be exactly what the client does not want to happen.
And Sharon, remember that Pete also has assets in France, which is not a common law country like the other three that we discussed. Civil law countries impose forced heirship rules that can override any provisions that are contained in a will. The EU introduced a regulation known as Brussels IV, and this was to provide certainty when determining which country's succession laws will apply when dealing with a client like Pete. The only EU countries that did not accept the regulation included Denmark, the UK, and Ireland. In terms of this regulation, the country's succession laws where the deceased was habitually resident at the time of death will apply. So in Pete's case, being habitually resident in the UK and and France accepted the regulation, the UK succession laws will apply. However, if one looks at the UK succession laws, it will refer the succession back to the country where the asset is situated when dealing with immovable property. So even if the UK laws applies in respect of the EU countries, forced heirship can still apply in respect of the immovable property in France. So this can be quite confusing, to say the least.
Yeah, no, you can say that again. And if you think about it, so you've got a to and a fro going on here, because obviously the UK is no longer a member of the EU, so they will never ratify that regulation. So they're sitting outside, and now you've got France that says, okay, well, the UK law will apply, and then you've got the UK law that says France will apply. So it doesn't eventually make sense to any normal person trying to make sense out of his financial planning out there. But I suppose that's why we are here. And it then raises the question, rather than providing us with certainty, and this is why you should be delving deeper to find that answer. As UK law looks back to where the immovable property is situated, it confirms that immovable and movable property can now also be dealt with differently, because depending on the circumstances, like in Pete's case, you will have the movable property, which will be dealt with by the UK laws, but then because the immovable property is situated in France, that will be dealt with in terms of the French laws. So forced heirship will apply towards the immovable property, and then the UK laws will apply towards the assets sitting elsewhere in the world, all the movable assets. And meaning that if the will in South Africa was valid in terms of UK law, then that will now dictate what happens to all the movable assets. And then we also have to see, looking at movable and immovable, and more relevant to our lives, is financial assets. And financial assets is it movable or immovable? Now it's obviously sitting within the movable side of the pot, so it will be dealt with in terms of the laws applicable to the movable assets. But then we've got another layer of products, and that is our insurance products. And now we've got a contract between the insurer and the client. So let's assume Pete had endowment policies in place. Where will they be governed by? What will be the case in?
Sharon, I think, and that's exactly what you said. It's a contract. It's a contract between the insurer and the insured, and that will be governed by contract and not by let me say succession laws, if there's a beneficiary. So if you've got a beneficiary and the contract allows you to have a beneficiary, that contract will apply and not the succession laws. But if you don't have a beneficiary on that contract, obviously that's an asset in the estate. It will pay to the estate, that's an asset, and that will depend where it pays out. And that can be governed by the succession laws of the relevant country. So if there's no beneficiary and no nominations, only then we can say that it will fall into the estate and be administered according to that country, whatever country is applicable then, according to their laws.
For movable assets, because they're...
For movable assets, because it's basically a monetary payment.
Okay, and then also just to make it clear, it's part of the estate then from a estate administration process. We will actually probably discuss estate taxes in a following Global Citizen event.
Yeah, and we spoke about it previously as well. There's certain countries where the beneficiary will be taxed on a payment received from policies.
Yeah,
so it's not clear-cut that it's a tax-free payment.
So that's a whole nother discussion.
Yes.
Yeah.
It's also probably an appropriate time to mention probate, as beneficiary nominations are known to prevent the application of the probate process. And probate is nothing other than the estate administration process that is followed to distribute the assets from the deceased estate to the beneficiaries. So where a client has assets in multiple jurisdictions, it can become cumbersome, as each jurisdiction will have their own probate process that must be followed. So we often see clients and advisors attempt to avoid it where possible.
As mentioned earlier, Jeff and Lucy from Momentum Trust will be chatting a bit later, and they will be chatting about wills and then also looking at the probate process and what you can do to either prevent unnecessary probate from taking place, and also keeping in mind that it depends on what products you use and what the outcome is on the probate that you will be faced with. It is clear that there is nothing simple when looking at international estate planning. It emphasizes the importance of the support structure that a financial advisor needs to create for himself when advising clients on the globe, really. And I think it's an opportune time to maybe just tell our financial advisors out there that the legal advisors within Momentum, we are there to assist them. We are well positioned to gather the necessary information that they will need when they need to advise clients on international matters. And I think we've got experience and we've got a panel of experts that we can tap into to refer them to if the situation necessitates or finds it necessary for them to use a specialist. whether it's tax specialists, whether it's estate administration, will drafting. I think we're well positioned to assist them. International estate planning is treacherous to say the least, and there is likely a different outcome for each and every client that you may deal with. And when relying on international treaties, one obviously have to determine whether they apply or not, as we said earlier. And that is sometimes quite tricky because it's not information that is just public knowledge. You have to go and look for those answers. And if a country did not accept the treaty, it means that they are not bound by that treaty and that they will fall back on their own laws. And that is then where we have to determine what are those laws and how it's going to impact on your succession plan.
That is why, Sharon, it is important to control what we can. When giving financial and investment planning advice, you have the opportunity to select products and solutions that can simplify and provide succession certainty. One size certainly does not fit all, but there are solutions that can be used to circumvent some of the complexities, like, for example, using trusts, companies, life wrappers, for example. But I would also like to emphasize that when considering setting up a trust, it is vitally important that you consider the residency or the future residency of the potential trust beneficiaries. As some of the countries like the UK, the US, and Australia does not look favorably upon the foreign trusts, thereby imposing harsh tax consequences. And by implementing a structure to solve the client's succession woes now, could very easily be proven to be the source of the woes to the next in line. So we have to be very careful when it comes to that.
This is a very important point you're making, Sanusha, and we often tend to focus on the client's situation now and not taking a bird's eye view of what's going to happen in future. And as we saw with Pete, he's got kids sitting in 3 different jurisdictions, of which might not be so open to foreign trust benefits coming to their tax residents, which we've now seen happen in real life, and sometimes quite harsh tax implications is the consequence thereof. So very important to make sure that we look at the client and then also at everybody that sits around them. And it highlights the importance of having a circle of support. I would like to take the opportunity to just remind our financial advisors that when they create their circle of support, the Momentum Legal Advisors are obviously there to be part of that support system, and that we are very well positioned to gather the information necessary for them to give the best and most appropriate advice, and where necessary to again go and find the specialists on the outside that we can refer them and the clients to when the situation dictates and necessitates that. Because not all scenarios are simple, and you need a lot of man hours and expertise to advise certain clients and their estates.
Very true.
So we're coming to the end of our discussion. Emil, Amanda, Sanusha, thank you very much for sharing and your valuable contributions that you've made today. I trust we've highlighted some interesting points. The intention of this session and of Global Citizen is never to necessarily give us all the answers, but it's to emphasize that we have to start looking and asking the questions, because that will then ensure that we can find the suitable answers. And in our next session, as I said before, Momentum Trust is going to be talking, and we've got Jeffrey Wiseman, who is the head of Momentum Trust as a whole, and then we've got Lucy Libber, who is the head of our Estates Department, and they will share practical insights based on their experience on international estate administration. And I know Jeff will specifically look at 1 will and 2 wills, and also the probate process. So I think a lot of useful information is still to come. So thank you.
Thank you, everyone, for your insights. You illuminated the complexities of navigating diverse legal frameworks and jurisdictional nuances in estate planning across borders. Emphasizing a client-centered approach, you highlighted the significance of tailored solutions to meet individual client needs. Your expertise provided invaluable guidance and understanding, addressing the intricate landscape of international estate planning effectively. Next, we have Jeffrey Wiseman, Head of Momentum Trust, and Lucy Libber, Head of Estates, who will provide insights on the cross-border estate administration and wills across jurisdictions.
Thank you, Francois. It's good to be able to join you this morning to talk to you about cross-border estate administration and wills across jurisdictions. I'm Jeffrey Wiseman, I'm Head of Momentum Trust, and I'm joined this morning by Lucy Libber. Lucy is our Head of Estates at Momentum Trust. I'm going to start this morning's conversation with a question that we often get asked by financial advisors and clients alike. And that is whether they should have a single will covering their worldwide estate, or whether they should have separate wills covering each of the different jurisdictions. My answer to that question normally is that it depends. It depends on two main things. Firstly, the nature and value of the assets. If the assets are complex and of high value, it makes sense probably to have separate wills in the jurisdictions where those assets are situated. The other aspect to take into consideration is the jurisdiction itself. There are some jurisdictions where the laws of succession are particularly complex. They have something called forced heirship, whereby the law determines who gets what and not a person's will necessarily. And those would be the circumstances where we would say it may be necessary to seek advice in those jurisdictions. We'll talk more about that during the course of the conversation. But I want to bring Lucy into the conversation right now and talk about the situation that we come across often in practice, where you have a client who is South African resident, they have a South African estate, but they have a single asset in a jurisdiction that we'd be reasonably familiar with, let's say, for example, Guernsey. And what's the process that we would normally follow in order to make sure that we can deal with that asset overseas?
So, Jeff, what happens is that once you get your appointment letter as executor, we get court sealed and certified copies from the master, which have to be submitted overseas to get the appointment. The court sealed and certified copies is the death certificate, the will, as well as the letters of executorship. And we also have to submit the original death certificate to the professional overseas. Once they have done to get the appointment letter, they will send back the death certificate to us.
Okay. And then one of the criticisms that we often say, or why people would prefer not to have a single will, is they say that it takes too much time to run both processes. So the South African process and then the overseas process subject to the South African process. What kind of timelines can a person expect when doing it in the manner that you're suggesting?
So, I think the only time frame that could maybe take a little bit longer is to get the court sealed and certified copies of the documents from the master. But we are using, at the moment, most of our estates has been reported in the master Johannesburg, and they quite quick to provide us with the information and the documents that we do need. And with the administration of the estate, once they've received the documents overseas, the two estates, the two executors have to be in contact with each other, because the one estate can't be finalized before the other one, because we would need information regarding the overseas estate to do our estate duty and the calculations for estate duty and everything.
So that's an interesting point. So if we run the estate through a single will, the two parties, the agent overseas and the local executor, will be in communication with each other in any event, because it's a single will. But what you're saying, though, is that even if they had separate wills, there would still be a need for the two parties to be in communication with one another.
Yes, definitely, because if it's a South African citizen and they've got worldwide assets, the professionals that's dealing with the estates overseas have to be in contact with us, because we need to reflect all the assets worldwide for estate duty purposes. And that could have an effect on cost and stuff that we have to pay and stuff.
So I think one of the interesting things related to that for me is that obviously there's estate duty implications, but sometimes there might be a sense that if I have two separate wills, I've got two separate estates, but that's not completely true, is it?
No.
It's one estate, but covered by different wills.
Yes.
So that means, in practical terms, that if a client has assets overseas and there perhaps are liabilities or cash shortfalls in the South African estate, it might be necessary to deal with or to liquidate some of the overseas assets to settle some of the South African debts.
That's true, because we had an estate recently where there was a liquidity issue in the estate, and we had to request from the professional overseas to transfer funds to our estate, that the heirs could keep some of the assets in their names instead of selling South African assets just to cover the shortfall.
Let's talk a little bit about costs. And like most lawyers say, the answer to that question also depends. What are the typical sort of charging structures, and what's the process that one would normally follow in appointing an overseas agent to attend to the administration of that part of an estate?
So if it's a cash estate or just like one asset estate, mostly the professional overseas only charge a fixed fee. But if it's a more complex estate where there's fixed properties and everything else, they do charge on an hourly rate. But what happens is they will send us the information, we will submit it to all the heirs, and if they do agree on the fees, then we will sign the power of attorney that they can act on our behalf.
So that is interesting. So that's one of the big differences potentially between how local executors work and how executors work overseas, in the sense that we're used to charging our fees on the basis of a percentage of the value of assets. And with international executors, they would agree to a fixed fee if they know that it's reasonably straightforward. But otherwise, they would quote based on how much time they think it's going to take.
Yes, that's true.
Okay. We've spoken about the South African resident who has an estate or assets overseas. What about the South African resident who has assets here and then moves overseas and he makes another country his home and he then dies with these assets in South Africa? What's the story, or what's the situation that applies in those circumstances?
So if there's a valid will overseas and it does, South Africa does accept, the master does accept that will as a valid will in South Africa, we do get, we will need then the original death certificate from that country. We would also need a copy of, or the original passport to get it registered, the death at Home Affairs in South Africa. And once we've got that, we can send everything through to the master, get our appointment as executors. But if the will is not accepted by the master's officers, we will have to do the estate in terms of the interstate succession. And then we will have to get a family member appointed. If not, then we will have to give security to administer the estate. So we can definitely do an estate even though there's no will.
So we would be able to take an appointment, let's say as Momentum Trust, to attend to that part of the estate. But because we're not related to the family members, we would need to give security. And so there would be, that's done by way of an insurance policy, and there is a cost associated with that.
Yes.
Perfect. One of the things that we do come across from time to time, we've had, in our discussions, there are two scenarios that spring to mind. The one is where you have a person who's a South African resident and he dies with assets in South Africa, and then he has assets situated in a country which applies this principle of forced heirship. So that's where the law says, it doesn't matter what your will says, this is how the assets are going to be divided. We come across a situation where they say they're going to do it on their own. The other circumstance that also happens is that you'll have people that will perhaps tell you about certain of the assets, but they'll keep some of the international assets. They won't give you sort of the full picture as regards those assets. What happens in those scenarios?
So, if they don't provide us with the information upfront when we do start with the estate administration, it really delays the administration, and we will need to get all the information from them and then get in contact with the countries where the assets are located and appoint a person there. So it really delays the administration of the estate if they withhold information from us.
So there are no shortcuts really. It's more important if we get the information up front, we can set the process in motion. And then, as I say, the one situation, we had a family where they wanted to deal with assets, I think, somewhere in Europe, and a number of months later they came back and said, we're not making progress here, and then they asked for our assistance. And certainly from my point of view, in dealing with these kinds of matters, it's certainly the more disclosure and transparency we can have up front, the better chance we have for a favourable outcome for the family.
So we've also had an estate where the estate was finalised, and then it happened that they tried to do the estate on their own, but they couldn't. So we had to reopen the estate on the South African side because for estate duty purposes. And then that's additional cost, and there's also penalties at the end for the heirs, because after 1 year, and if there's estate duty, there is interest that we have to pay. So I think the best would be most for the people to inform you from upfront that there are additional assets.
Lucy, one of the things that you've raised now that is interesting is that it doesn't really matter where you are in the process. So you can be in an estate and part of the administration, you didn't know about the assets at the beginning, and then you get informed during the process, and then you can deal with them. But even if you finalize your estate, and even if it's some time later, these assets are discovered, what's the process then? You need to reopen the estate, don't you?
Yes. Yeah, so we have to reopen the estate and do either you do an amended first and final liquidation distribution account or a supplementary account, because with the change in the estate duty, if the assets, if there are estate duty, we will have to get then the funds back also from the overseas estate, because the estate in South Africa has been finalised and there won't be any cash. So we will also have a liquidity issue that they have to pay then the funds over to us.
So yet again, if you are aware of the assets, make them known. Another practical consideration, and now we move a little bit into the advice space, you know, when the client's still alive. We have come across a few estates where the family's been aware of assets situated somewhere else, but they don't have the details of those assets. Perhaps just talk us through the process and the difficulties that you have and what you actually need in order to be effective as an executor in dealing with international assets.
So if we don't get exact information about an asset, especially if there's bank accounts or fixed properties, with fixed properties we would need a title deed, and with any investments and stuff we would need exactly an account number or anything. If we do not have that information, the professionals overseas can't help us, Jeffrey.
Yeah.
So until the time that the heirs have provided us or the financial advisor have provided us with information, then we can proceed with the administration of that estate. But it delays the estate if they don't provide us with that information.
So staying in the advice space, again, and now let's just look a little bit at some of the issues and where maybe a separate will is not a bad idea. So I can think of one estate that we were involved with a number of years ago where there was a property portfolio situated in the UK. And the issue there was, again, we've spoken about, you know, different charging structure. And because there were rental properties, the activity of the executor was quite high. And it was quite difficult for the surviving spouse to deal with the third party that we'd appointed in terms of how much they charged for attending to that part of the estate. And certainly, from my point of view, you know, having looked at that, that would have been a good example of a situation where maybe a separate will would have been a good idea, because that family would have been able to select the executor, and they would have been able to set off, on a good footing rather than to have been referred by a third party. But if we move into the world of forced heirship being the other reason to consider why to have a second will, that, as I've said, is where you've got countries in most of continental Europe. They make use of forced heirship. I suppose the closest in a South African context is that it's like the Intestate Succession Act applying to all estates. But other jurisdictions might be Mauritius. I think we do come across that. But certainly from an advice perspective, there would be circumstances where it might be a good idea for the client to engage an advisor and get specialist advice during their lifetime rather than to wait until they pass away. So Lucy, in your experience, there certainly are complexities associated with dealing with international assets in estates.
Yes. So yes, definitely. We've got forced heirship in estates, and for us, in that regard, it's better to get legal advice for planning before the person passed away, because it gets complex, and it's better for them to get it sorted out.
Absolutely. So I think there's certain things, that I'm aware of that people can possibly look at. So I know that if you've got fixed property in a foreign jurisdiction, it's the law of that land that determines the succession, whereas if it's a movable asset, then it's normally the law of the domicile of the person. So if there can be a big difference between dealing with movable versus immovable assets.
Yes, definitely, because with movable assets, it's got much easier to deal with it in terms of the will than with fixed property, because fixed property would be then in terms of the forced heirship in that country.
Yeah, 100%. So from a planning perspective, things that people have looked at are maybe there is an EU succession regulation that they may be able to access where they perhaps are able to bypass forced heirship. They might even be able to take a fixed property and transfer it into a structure so that it becomes a movable asset. And so those are all the kinds of things that a person can do during their lifetime. But once they're dead, it's too late, isn't it?
Yeah, no, it's definitely too late. The best would be to get your financial affairs up to date before you pass away.
Yeah. So I think for me, if we sort of look at sort of financial advisors perhaps guiding clients in this, I suppose there are a few principles that are very important. So the first that we've said, I think, is that the more information we have, both at the advice stage and also at the start of the deceased estate administration phase, that's the best way that we can ensure a good outcome for the family. That would probably be a starting point, wouldn't it?
Yes, I think it's to be transparent and also to advise the financial planner of all your assets and liabilities in your name, that they can help you to put structure in place that you can have the best outcome at the end.
I think one of the things that I've also sort of picked up is that it's impossible for a person to be an expert in all fields and in all jurisdictions. And particularly where you're dealing with high value estates, it's often better to make sure that you get the right experts on board as soon as possible and perhaps pay for that advice rather than wait and try and get an executor to try and sort out problems that were unforeseen at that time.
No, that's true, because it's rather pay now and have everything in order than getting the executor to sort it out, and there's more more issues and complexities in the estate.
Yeah, so I think that for me, if I sort of summarize what we've been saying as well, I think for me, the more complex your estate, particularly as regards international assets, perhaps look at 2 wills instead of just one. If you've got a single asset overseas, perhaps one worldwide will could work. I know that in our instance, we often deal with both simple and complex estates with a single worldwide will. And so problems can be solved. But I think the bottom line is really do your planning, solve the problems that can be solved during your lifetime, and ensure that your clients' affairs are in order. Thank you very much for joining us today, and thank you, Lucy, for your expert insight.
Thank you, Jeffrey.
Thank you, Jeffrey and Lucy, for illuminating key aspects of international succession planning and estate administration. Your emphasis on meticulous planning addressed crucial considerations such as wills, probate processes, and ideal succession plans for global citizens. Drawing on their expertise, Marius and Hannes will shed light on the intricacies of navigating international estate management and offer practical strategies for overcoming succession challenges. Their insights promise to equip us with valuable knowledge to better serve your clients' needs in the global landscape of wealth management. We welcome Marius and Hannes to today's panel. Hannes,
Yes, Frans.
both of you regional managers with Momentum Wealth International. Give me your best 2-minute summary of the MWI product offering.
So let's start off with what we call our international investment option, or in brief, IIO. So this is a discretionary product that supports co-ownership. It has limited estate planning opportunities, and the tax consequences is also fairly structured, or not a lot of planning opportunities. But for those investors who are no longer in the South African tax net,
Arguably, we've seen a lot of that recently.
Yes, a lot of investors immigrating and suddenly having to change from one product to the next. So that is a great solution for your investor who does not want to be in that more formalized endowment type product.
Okay, so that covers the international investment option, IIO.
That's the IIO.
Okay.
So if we move on, we have the international endowment option, or IEO as we call it. So this is a product that's structured on the branch model. I know it sounds Greek, but it's essentially similar to the typical South African endowment that many of you will know. It gives tax benefits, but for today's discussion, the important thing is it gives planning opportunities. Co-ownership, something that Marius will touch on, the beneficiary structuring that he will discuss, beneficiaries of proceeds, beneficiary of ownership, or as we call it, successor contract owner. And then if we look at the outcomes that this product can achieve, it's fairly well defined. There's 4 specific outcomes, and if you have a look at the slide on screen, you will see that you can decide upfront, where do I want to end up with this product? And all of these solutions are available within our product suite.
Marius, a popular spot for South Africans wanting to emigrate is the UK.
Correct.
That obviously complicates matters from a tax perspective. Do you want us to give us a high-level rundown of how the UK looks at tax, specifically for offshore endowments?
So the problem then potentially for the UK beneficiaries are that withdrawals or the ownership becomes an income tax event. So whether you're the owner or the subsequent owner, you might have to get proper UK tax advice to see what is best suited on those policies. Because as we mentioned on our life insurance bond, you can, for example, have a beneficiary for proceeds or a beneficiary of ownership. And I think that advice will govern which one is the better one. And I think because you correctly state that the most favorite place for people to immigrate to is still the UK, they need to investigate that thoroughly. And I think the fact that we have the life insurance bond where you can have ownership and proceeds just gives them a bit of flexibility going into the future.
And so the international endowment option, which now you've said covers both the life insurance bond and the capital redemption bond,
Yes.
gives you the ability to better structure and try and solve for certain outcomes.
100%. Basically what we're saying is that the sinking fund, you can only nominate ownership, where on the life insurance bond you can nominate ownership and proceeds. So therefore, we just believe that the life insurance bond gives you more flexibility.
And Francois, not every product supplier have both these options available. We are one of the product suppliers who have both a sinking fund and a life-linked product available in our suite of products.
Correct.
Thank you, Hannes. And I guess that opens up so much avenue in terms of, structuring ability.
Yes.
Correct. If you look at, if we move on to the typical scenario where someone may have been living in South Africa all his life, now he's immigrated, he's in the UK. So if we look at, for example, our IIO, that's a purely Guernsey-based nominee company. That's the underlying nominee on that product. And that means that the attachment to South Africa is much more removed than in many other instances. We also have the opportunity where you can actually transfer from the IEO into an IIO. Of course, that's a decision that must be only made after all that have been considered, but it gives you the opportunity to move between products, which is often not available with other product structuring.
But Hannes, if you move from IIO to an IEO, what happens to capital gains tax?
That's one of the aspects that needs to be considered. Remember, inside the international endowment option, we have tax dispensation, section 29A of the Income Tax Act, 5 funds as it's popularly known. So there will be consequences. So the important part is, again, you need tax advice, not only in this jurisdiction, but also, let's call it in your target jurisdiction. It's a multidisciplinary approach that you will have to take in certain circumstances.
Thank you, Hannes. Now, my next question almost leads me into probate. You cannot have a discussion surrounding structuring, surrounding global citizenship, surrounding product options if you don't cover probate.
Yes.
So quite a hot topic at the moment.
Yes, I'll elaborate on that one. So just talking to what we've said before, we've got these 3 products on Momentum Wealth International. If we look at the endowment options, we spoke about beneficiaries for proceeds and beneficiary of ownership, just depending on which endowment you use. In those endowments, furthermore, we also have joint and survivorship between spouses, which is a succession planning tool. And then, as Hannes mentioned, on the IIO, you can have joint and survivorship if you have more than one owner on the IIO. So if you put these structures in place and do the nominations correctly, then probate shouldn't be an issue in your life. However, we do have established relationships with professional entities offshore, which, for example, can draw up an international will for you free of charge. And they also charge the fixed fee for transferring assets. So if you plan for probate, appropriately and accordingly, it really should be a seamless process when it comes to probate. But if the nominations in your product is correct, then probate should never be a problem.
Perfect.
And even if you are invested in the IIO, it's fairly simple to combine an offshore will, single asset offshore will, to provide for how that product must be distributed to your beneficiaries who may be living all over the world. So there's a combination of estate planning options that we have available, either in our product lines, or if you look at the people we are partnering with in different jurisdictions, that gives you this opportunity to transfer your wealth to beneficiaries who are no longer in South Africa. On that point, over the past 2 years, we've seen a lot of articles in the media, the international financial media, about the intergenerational wealth transfer. And we've got a nice slide on that topic showing how in the next 2 decades, there will be a huge transfer of wealth to millennials. Now, millennials being people...
Next generation, right?
Next generation. So the importance of that fact is that, number one, estate planning is becoming more and more important. It has always been important, but it's actually more important at this stage.
Now more important than ever.
Correct.
Definitely. And then secondly, from an advisor's point of view, you need to bear in mind that you are, or your assets under advice may be under attack when these heirs take the inheritance they received from their parents, from their family members, and move to different advisors. And on both those two levels, Momentum Wealth International can help you to plan. We've got the expertise, we've got the products, we've got the partnerships, but also we can help you to retain those assets under management. Francois?
Thank you, Hannes.
100%, and I just wanted to add to Hannes is that you might find that a structure that suits a client is beneficiary of proceeds. So the heirs get the proceeds, and what now? This is where the international investment option comes into play. They might be in a different jurisdiction where an endowment isn't suitable anymore, but the advisor can maintain the assets under management by putting that proceeds, if you want, in an international investment option, therefore still advising the clients and just keeping that assets under management.
Hannes, a very popular investment vehicle used by high net worth individuals that has been under increased scrutiny is the use of offshore trusts. How does offshore trusts fit into the whole estate planning and structuring theme of today?
Francois, a very good question. So yes, it's true that in the last 15 years we've seen, especially in South Africa, but in other jurisdictions as well, trusts being under attack. We've also seen the rise of what is popularly called a dry trust or a freezer trust or a passive trust. So let me explain that in a nutshell. It's essentially where, and I think it was touched on by one of the previous technical discussions as well, but where, think of it as a testamentary trust that's created during the lifetime, that it will serve as a pour-over trust in the event of the investor. It means that there might just be a nominal donation of £100 in there during the lifetime of the investor, and then when the investor dies, it will transfer, his wealth will transfer into this trust. That, of course, means that you sanitize those assets from estate duty in future generations' hands. There's other benefits as well, such as protection against creditors, etc., etc. But for today, the important thing is to look at the estate planning benefits. So we've seen the rise, I wouldn't really call it the rise, but we've seen dry trusts being used way much more. We have partnerships with businesses who can assist the audience and their clients with establishing those trusts. The important thing is when you use those types of trusts are to, number one, understand that offshore trusts are typically not the same as we experience in South Africa. For example, the control of the donor is more constricted in an international arena as opposed to what we are used to in South Africa. And then, of course, the cost of that structure, establishing it, maintaining it, that's something that needs to bear in mind as well. But it remains a good technique for estate planning purposes. But bear in mind, many of the outcomes that you can achieve with a freezer or a dry trust, some of those outcomes can also be achieved by using the international endowment option. 100%.
And why do you say that, Hannes? Do you want to just quickly unpack, that statement?
For example, let's start off with beneficiaries who are perhaps not capable of looking after their assets. So you want the endowment only to vest at a future date. So you can postpone the vesting of the product by adding additional assured lives. That would be one example of how you can, almost like a trust, where a trust looks at generations, where you can bring in additional generations into the endowment by having additional insured lives. You can add insured lives under certain circumstances. You might even be able to take them away. But that's a technical discussion for another day.
And I think what's important here is almost this fact that each and every client and each and every one, circumstances are different. And it's important that you have a very specific outcome in mind, and then how you structure to achieve that outcome is best done on a case-by-case basis.
Very, very true, very true. The cookie cutter approach is not going to work for every client. Basic structures remain the foundation, but typically when you're building the house, each client will have a different house.
Exactly. And, if you think about it, the structure that you start off with might not be the structure that serves the client in the future. And I think that's the beauty of our platform. So you might start with a client structure as a beneficiary of ownership. The beneficiaries might move to the UK, and as we spoke about it earlier, it might be better to change it from ownership to proceeds.
And the product suite has the ability to evolve and almost grow as your clients,
100%,
grow.
100% correct. Once again, this is the flexibility that our products offer. You don't have to stick to the structure. Clients move around to different jurisdictions, and you can adapt the product to suit the client's needs. Ownership can be proceeds, and later you can change it from proceeds to ownership, for example. And as we also spoke earlier, a client might be well served by an endowment now, but 3 years from now they've immigrated potentially. So there they might want to take the money out of the endowment, start a list product. Clients might want to return to South Africa if the immigration doesn't work out. They can collapse the list product and go back into the endowment because we facilitate it via loans. So I think the important point is that our product suite, and I think financial advisors must think about who they partner with in the international space. Partnering with a platform that has a wide range of choice, that is flexible and adaptable, I think is very important, because I think not one product can solve, for all the clients' different needs, international circumstances out there.
I'm going to put both of you on the spot. A lot was said today. A lot was discussed. I want each of you to please give me 2 broad themes that you want to leave our advisors with.
Francois, let me start. I'm from an Afrikaans background, so the adage just doesn't come so easily to me, but I know there's one in English that's saying no man is an island unto himself. And I think the same is true for financial planners. You are not on your own. You cannot go alone. You need the right partners on board when it comes to the financial planning, the estate planning of international clients. And Francois, to me, that's the most important message I want to leave with the audience today. You cannot do this on your own. You need help. Francois?
Thank you, Hannes. Well said. Marius?
For me, Francois, I think the important thing is, we've looked at succession planning and realized it can be very complex depending on the client's situation. So I think, therefore, clients need financial advisors to give them proper advice. And I think financial advisors, they need to partner with the correct international platform that can offer them choice and flexibility and adaptability in terms of international succession planning.
Thank you for joining us today on our 3rd Global Citizen series. Today, we unraveled some of the complexities in regards with estate planning and succession. A few key takeaways for me. Momentum believes in the value of financial advice. Secondly, each and every case can be fairly complex, but the range of products that Momentum has means that we can solve for almost any potential outcome. Gentlemen, thank you for your time and the valuable expertise that you shared with us today.
You're welcome.
Thank you very much.
I extend my sincere gratitude to each of our esteemed speakers for their invaluable contributions to today's enlightening discussion. Additionally, I want to express appreciation to our diligent advisors for your active participation and insightful engagement. Looking ahead, I eagerly anticipate the continuation of this dialogue in future, as we strive to further explore and address the ever-evolving opportunities in global wealth management. Your expertise and dedication will undoubtedly play a pivotal role in shaping our collective success. Thank you all for your unwavering commitment to excellence.